Wondering if the police can track you because you were near the scene of a crime? Curious as to the legal issues revolving around Google sharing information with the authorities? Today I look at geofences and how they can be used by police to get a warrant for your smartphone location. Hi, this is Professor Bo Bias. Smartphones are ubiquitous, just like coffee shops and grocery stores. Almost everyone has one, with numerous apps to make our lives easier. Ask yourself, when was the last time you pulled out a paper map to find a location or asked a stranger to guide you to the nearest restaurant? You've either never done this or you haven't done it in years. Instead, you pulled out your smartphone and you asked it to give you that information. But did you know that Google and other companies keep track of that information and will provide that information to the police when they are required to do so by law? Because our smartphones leave traces, let's explore how and when the police can get a warrant to force Google to provide your location to them. A geofence is a geographic area around a specified location, with Google being able to pinpoint a device within 20 meters or about 65 feet. In one case, the police obtained a warrant ordering Google to provide them with the identity of every device within 150 meters or about 500 feet of a bank robbery location from 4:20 p.m. to 5:20 p.m. This was during rush hour. This request not only captured data from those at the bank, but also from devices at a restaurant, 2 apartment complexes, a hotel, a mini storage, and a large church across the street. And how about the busy road right next to the bank? The legal question I now want to discuss is the legality of the warrant ordering Google to provide this information. Before I go any further, let me note that Google has publicly stated that they will follow the law. And, to my knowledge, they have provided this kind of information only when ordered to do so by a court of law. One Google employee noted that they get nearly 200 warrants a week, and I suspect that number will grow over time. In the United States, police action is restrained by the Fourth Amendment to the Constitution, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or thing to be seized." The writers of the U.S. Constitution were concerned with the abuses they experienced by the British before the War of Independence. The concern animating the Fourth Amendment was the use of general warrants by the British authorities. The British would issue a general warrant, also called a writ of assistance, to an official charged with enforcing the laws. The warrant could then be used to search any place, anyone, at any time, without suspicion of wrongdoing and without payment for damages caused in the search. The general warrant is viewed as a significant contributing cause to the American Revolution and the reason why the Fourth Amendment has specific requirement as to when a warrant can be issued. So in the United States, general warrants are unconstitutional and illegal. This brings us back to our initial question. Is a warrant ordering Google to provide geofence information a general warrant and therefore illegal? Now, if the government were to get names and addresses of all Google devices using geofence data, that would likely violate the Fourth Amendment because that looks a lot like a general warrant. But the government has not been doing that. Going back to the bank robbery case, the government requested the data in a manner that protected the identities of the device owners. Google provided anonymous ID numbers instead of names, along with the geofence data. The police then looked at the data to reduce the number of potential suspects, eventually zeroing in on the person they eventually arrested. They found evidence of the bank robbery at that person's home. The government's legal argument relies on an ambiguity in the Fourth Amendment itself. Is the Fourth Amendment primarily concerned with unreasonable searches, or is it concerned with meeting the warrant requirement? Chief Justice Rehnquist stated in Ohio versus Robinette that, quote, "The touchstone of the Fourth Amendment is reasonableness. Reasonableness, in turn, is measured in objective terms by examining the totality of the circumstances," unquote. With this in mind, we now need to determine whether the police acted reasonably when using the geofence data from Google. What is clear is that the police were careful to avoid exposing all 19 individuals to personal scrutiny. Using only anonymous data, they winnowed the potential suspects down, eventually identifying the one bank robber. So yes, what the police did was reasonable, but at the same time, they did it through the use of a general warrant. I suspect that when a geofence data case makes its way up to the Supreme Court, the decision will be grounded in terms of reasonableness and not in terms of the warrant requirement. This is because the court is extremely concerned about privacy rights, which ultimately was the problem with the general warrant. So while the data of 19 individuals were initially searched, they were searched anonymously and privately. The government never identified personally who they were searching. All they really knew was that a device owned by someone was at a particular location. Only through more effort were the police able to identify the one device that appeared to be that of the bank robber. Do you have concerns over geofence data? If so, share them in the comment section below. New videos every other Wednesday, so hit the subscribe and bell button so you can become a better student and a better lawyer.